Morning, my lord. My lord, can I pick up on 4 residual matters arising out of my submissions yesterday? First is that my Lord Justice Mayles asked me about whose logs were shipped from which ports. And I've taken instructions, and I can say on instructions, that logs from all 3 exporters were loaded from Tauranga port. Logs that were exported from Napier were invariably OTPP logs, and logs loaded at Marsden Point were invariably Tuamata logs. So if Tuamata or Napier, if Marsden or Napier were identified, that would give the person a big clue as to whose logs would be loaded, but that wouldn't be the case in relation to Tarawanga.
Yes. Which is where all Tiaki logs then must be.
Yes, all of their logs came from there. Yes.
Yeah. Well, thank you very much for taking instructions on that.
Sorry, I didn't know the answer yesterday.
I hope it didn't mean a conversation at some unearthly hour because of time zones.
I think it was done electronically, and therefore everybody was able to deal with it when they're awake. Because it was back, so yes. My Lord, the second point was a question from my Lord Justice Zacaroli, which was, is it possible that 521C could apply in a situation where shipping was involved? And just to clarify my answer, I don't think it was incorrect, but just to clarify my answer to my Lord's question is that 5.2.1C could apply in 2 ways. Firstly, it would apply if shipping entered into the charter party as agents for forests as an undisclosed principle, but that was ruled out by the finding of the judge below. And the second way it could have happened is that forests could have taken a sub-charter from shipping. So in other words, just as shipping chartered the vessel as disponent owner from Berge, so could forests have sub-chartered the vessel from shipping, but that didn't happen on the facts. The third point is that the Rochdale case that I mentioned during the course of my submissions yesterday has, I hope, found its way into the authorities bundle.
I was given a copy separately.
Oh, good. Well, I'm very pleased. Sorry, I didn't. I tried to put that in motion, and of course, my own friend saw it last night after court. I think the relevant paragraphs, we did put a red line against you. Your Lordship may have noticed, and it's paragraph 49, I believe. And it's what I was picking up on was was what Lord Justice Rick said in paragraph 50, the first sentence, when he says those conclusions seem correct to me, and the conclusions he's referring to are is the quote from the judgment referred to. It says the key principles to be derived from various cases in which the words "on behalf of" are being considered are as follows. The phrase "on behalf of" does not have a fixed meaning; it's not a term of art. The phrase is capable of bearing a wide range of meanings. And 3, it will take its meaning in any particular case from its statutory context. Now, obviously, we would suggest the word statutory context in our case should be a contractual context. And as your Lordship knows, my submission is that the SSA, when construed against the background and the purpose to which shipping was incorporated, does not amount to an agreement whereby shipping was appointed either as an agent or a sub-agent for exporters. And then the fourth and final point, my Lord, is in answer to a question from my Lady Justice Falk yesterday concerning the mechanics of clause 521F. I said that there was no email chain in relation to each offer and acceptance, and that was correct. But I do need to add 2 points to complete the answer. The first is this: that when you look at clause 5.2.1F, which is at Supplemental Bundle 1, Tab 1, page 15. The first point is that there's no requirement that the offer and acceptance be in writing. So the absence of an email chain is unsurprising. And the second point I needed to add is that, that there was extensive evidence before the judge below to the effect that the offer and acceptance process was supplied as part of the SOP standing for Sales and Operations Process. And there was detailed evidence on that before the judge, which is in the supplemental bundle. It's in tab, or bundle 2 at tab 65, which I don't think we've looked at before, beginning at page 418. This is a witness statement served on behalf of Forests. At 418, it begins at subparagraph 17. All shipping requirements are developed through the TPTF sales and operations process. And there's probably not useful use of time now to read it all, but then there's a detailed series of paragraphs giving an explanation of how that process worked, going through to paragraph 32 on page 421. And then the key points, at least so my lady knows what the case was, what the evidence was, it is in 33, 34 and 35. With such a comprehensive system in place and against the background of such significant cargo volumes, there was no need for any vessel-by-vessel request and approval with the export client, nor as stated was any required by 5.2.1f. And then, thus given these policies, operating procedures and practices governing the agency relationship between forests and exporters, there is no question that a process was in place and was followed for the offer and acceptance approval contemplated by clause 5.2.1f. And then 2 more paragraphs over the page. So I should have referred my lady to that evidence which was before the judge.
Okay, so that evidence is, you've accepted, is to the effect that there was some process fitted with paragraph F.
Exactly. That was the evidence before the learned judge, and I should have referred you to it. Now, my lord, I need to finish, if I may, ground 1, and I've got 3 topics. They're not as difficult as some of the material I'm going to be dealing with later, so I'm going to take them as quickly as I can. The first is the flow of funds point. And the first point is, it is true, and it's accepted by my clients, that shipping made no profits on the carriage of my clients' logs. And the reason for that is because my clients agreed under the marketing agreements to pay for the costs of carriage, i.e. the net of freight plus demurrage less dispatch. The second point is it's important in our submission to recognise that dispatch is simply a credit against freight when lay time, which of course is paid for as part of the freight, is not fully used. Dispatch, like demurrage, forms part of the net cost of carriage, which is accounted for as part of the wash-up procedures. And the reason my clients were credited with dispatch as part of the wash-up procedure was not because they were charterers, but because they were liable to pay the cost of carriage. And your lordship will have noted, or I'll show you your lordship in a moment, or at some point this morning, that the sales contract provided, in fact, that the buyers were ultimately responsible for demurrage. In terms of who benefits from the LOI, ultimately it's the buyer, not the seller. So, my lord, that brings me to the 3 key submissions I want to make on the flow of funds point. The first point is this. The fact that shipping did not make any profit from the carriage of my client's logs, we submit, is entirely consistent with the commercial and contractual purpose, which was to ring-fence the risk of losses and liabilities inherent in the chartering operations within shipping. And there is nothing, and I wasn't suggesting yesterday that it was, there was nothing improper in that. And indeed, it gave the wider TPT group and forests a particular advantage in terms of their competitive market advantage. And it was, of course, forests who were actually earning the commissions from exporters. The second point is that if shipping was in fact acting as an agent, one might have expected it to see that it was earning a commission. But of course, no remuneration was charged or agreed. And then the final point, my lord, is this, that the fact that shipping performed the shipping services at cost is a neutral factor when considering whether it was acting as a principal or agent. And on that point, my lord, I do rely upon the judgment of Mr. Justice Leggett, as he then was in a case called the Magellan Spirit, which I don't think we've looked at properly. It is an important case. Now, I just show your lordships, my lady, the relevant paragraphs. they're in bundle A2, tab 34, and paragraphs 28 I've got the wrong glasses on, so I can't read this one. 28. If I can pick it up at 28, my lord, at page 641. This is where Justice Leggett begins the analysis, and he starts by saying, where the contract is made on behalf of a named legal person, nothing in the contract or surrounding circumstances to indicate the other contracting party that the named person is making the contract as an agent, then there's a presumption that he must be contracting as principal. And of course, it's possible to displace that consumption, but you need convincing proof to do so. And then paragraph 29, the most obvious method of proof would be an express agreement establishing the agency relationship. And I've made my submissions on that already as to the effect of the SSA. And my submission, you know my case on that. And then, in terms of the analysis, the evidence in that case, that begins at paragraph 30, and it summarises the position, which is very similar to the position in our case. Firstly, Mansell, which is part of the VSA, the Vitol Group, was established with the intention, this is paragraph 30.1, the intention of ring-fencing, being ring-fenced from the group's trading operations. And little 2, where, reading between E and F, where, however, Mansell enters into a time charter solely in order to meet the shipping requirements of another Vitol Group company. The vessel is operated by Mansell at cost. This means Mansell is reimbursed by the other company for all costs incurred in operating the vessel, but does not receive any other payment, makes no profit or loss. And then the key paragraph, my lord, is at paragraph 33 across the page, at page 643. For the owner, Mr. Timothy Hill, QC, submitted the court should look at the substance, which is that the Magellan Spirit was chartered solely for the use and benefit of VSA, with the intention that Mansell would make no profit and suffer no loss from chartering the vessel. I agree that this is the effect of the evidence. I do not accept, however, that these facts are sufficient to show that Mansell intended to enter into the charter as an agent for VSA. It's true, if the evidence showed an intention that the vessel would or might be operated by Mansell for its own profit, that would have been inconsistent with an agency relationship, but the converse is not true. It is perfectly possible to have an arrangement between parties dealing as principals, whereby one agrees to make a ship or other property available for another's use in return for reimbursement of all operating costs. The critical difference between such an arrangement between principals and an agency relationship is the principal may sue and be sued on a contract made by an agent on his behalf. In order to infer such an intention, the Mansell should charter the Magellan Spirit as agent for VSA, it would therefore be necessary to identify conduct which signifies an intention that his VSA should have rights directly against or liabilities directly towards the owner. So obviously that's a case on its own facts, but we've submitted the same analysis as applicable here, and therefore the flow of funds point is essentially a neutral one. The other point, my lord, is the question of the sale of space to third parties. And again, that picks up on the point made by learned Judge Mr. Justice Leggett, then was that if, having chartered the vessel, it did or might have made a profit for itself, that's an indication against there being an agency. Now, in our case, it's true that the figures themselves, which we're dealing with here, were not large. I quite accept that. They're set out in my learned friend's skeleton argument, which is in the core bundle at tab 12, the easiest place to see it, page 128, paragraph 26. So in terms of what shipping earned on the Cosmos Harmony, the figure is $5,265. In terms of the TS index, the respective figure is 11,374. Now, I accept that those figures are small. But in my respectful submission, they are not so small that they can be completely ignored And what matters is the fact that shipping sold space to third parties such as F36O and PBL for its own account, and that's the matter that's important as a question of principle. And again, I rely upon the Magellan spirit of paragraph 33, and what the learned judge says there in support of that submission. And that's a further point we would submit in support of the learned judge below's conclusion that shipping contracted as principal when it entered into the charter parties. And that leads me to the final topic on ground one, which is the accounts point. I don't think you were shown them, but the accounts themselves, my friends rely upon, are in the supplemental bundle. They're in supplemental bundle 1, tab 17, 179. And what my learned friends below sought to say is that these documents, these financial statements, are consistent only with shipping having contracted as agents. And the judge found that submission was not made good. Now, my submission response is that was a perfectly legitimate decision for the judge below to make, one he was entitled to make, and indeed, the reason I'm about to explain was obviously the correct one. Now, picking up a couple of points. Firstly, you will have noticed that these are called special purpose financial statements. Contrary to actually what the learned judge said, they're not audited accounts. One can see that from page 181, which is a compilation report from KPMG. You'll see the first thing, paragraph 1 of the first heading paragraph, which is important, is that they're actually being compiled under some New Zealand legislation, namely the Tax Administration Financial Statements Order 2014, which allows, apparently, the preparation of something called special purpose financial statements. And we see in the penultimate paragraph, we have no audit or review has been performed, and accordingly no assurance is expressed. So they're not audited, they're special purpose financial statements. And so that's the background. Then when you actually look at the relevant page, 184, under revenue, what we see is net income. Charter income, which is expressed as gross surplus, as being 100%. Now, that gross surplus, that's the profit. So what we don't have is all the freight going out and all the freight coming in. All we have is the net figure. And the key point is we don't know why. And of course, my Lord Justice Zacaroli was right yesterday in saying, in any event, this point would be a neutral one because, as agents for an undisclosed principal, shipping had the liability anyway, as a matter of law. So at the end of the day, my point is a very short one. The judge was entirely right to say he gets no assistance from the accounts or financial statements in terms of seeking to identify in what capacity shipping entered into the charter parties. Now, that brings me to my conclusion on ground one, which is this, that my respectful submission, there are no identifiable flaws in the judge's reasoning on ground one. The judge's evaluation of the evidence led him to conclude that my clients have the better of the argument to the effect that shipping entered into the charter parties as principal. The key reason for that is because we have the better argument that the charters were entered into pursuant to the arrangements contemplated by clause 5.2.1f of the marketing agreements. And in those circumstances, my respectful submission, there's no proper basis for an appellate court, given the nature of this review, which we discussed yesterday, reviewing an evaluative decision such as this to disturb the judge's conclusion on ground one. So that brings me to ground two, and ground two is recognised by my friends as being the crucial ground. He has to win on ground two to win the appeal. Now, the starting point is, of course, an analysis of the judge's reasoning on ground 2. And we looked at this, I'm sure you've looked at it more than once already. It's in the core bundle, the judgment, tab 14. And judge's reasoning on ground 2 against my clients. This is the LOI point, paragraph 74, pages 170 to 171. Now, his primary, what my friends in their skeleton scrub, the ratio of his decision is in paragraph 74.1. I've already found that Forrest had the better of the argument that the LOIs were issued by shipping on their own behalf. Now, that's consistent with what he says in paragraph 74.4, where he says, if, contrary to my findings, Forrest had indeed authorised the issuance of LOIs, then they would have had no authority to do so. And it's also a reference back in my submission to his findings in paragraph 63, and in particular, paragraph 63.4, which is on page 166.
Sorry, what was your first cross-reference? You said consistent with, I thought you said 74.4 before you go...
You did, but I think you meant 6.
I'm so sorry. Yeah. 74.6, I beg your pardon, my lady. Quite right. Yeah, I'm going to have to change my glasses, forgive me. That stage in life. Unfortunately, I need different glasses for different things. Right.
Probably means you won't be able to see us now.
Well, I can see you well enough, my lord, and I can hopefully read much more effectively. Yes, my lady, I'm sorry, you were quite right. It's 6.
Yeah, got it. Thank you. The next one was 63.4.
Yes, and the other one was 63.4, which is at 166, where the learned judge said, I also accept Mr. Rainey's submission that there is an obvious reason why shipping would want to seek Forrest's approval for the issuance of an LOI and the discharge of the goods, which was that the goods represented security for payment for those goods. When those goods were discharged, that security would be lost. And we'll look at it in a minute, but what Mr. Rainey's submission, which has been accepted in that paragraph, is that contrary to the owner's case that Forrests were being asked for and gave authority to issue an LOI on behalf of a third party, that's not what was happening. What was happening was that Forrests were being asked to consent to the issuance of an LOI in circumstances where doing so would mean that the security represented by the cargo for the price of the goods would be lost. So that was the primary basis of the judge's decision on ground 2. And then the second ground, which he described as hypothetical, is that even if, contrary to that finding, Forrest had authorised the issuance of LOIs, nonetheless, they had no actual authority to do so, and as a consequence, shipping had no actual authority to issue those LOIs on my client's behalf either. And for that reason, my clients were not undisclosed principals to those contracts. Now, that's the context of what the judge decided. And what my learned friends say, and their main point, vitiating mistake, I think they called it, is that there is a logical flaw in paragraph 74.1 of the judgment on the basis that the judge had not found and didn't find that shipping issued the LOIs as principals rather than agents. Now, superficially, one could see why and how that point is taken. But when we unpack it, which I'm going to try and do in a moment, in my respectful submission, it leads to the conclusion that is not a valid criticism of the learned judge's reasoning. And the reason I say that is because when we look at what Mr. Rainey submitted and what was being accepted, it's clear in my submission that what Mr. Rainey was submitting was that Forest's approval was given for a particular purpose and did not amount to the giving of authority for the LOIs to be issued as agents. And it's important also to recognise the dynamic of the hearing below. And I say that because, of course, at the time, my own friends were alleging that both Forest and my clients were undisclosed principals, either together or separately or in some combination. And many of the points that were being taken overlapped between myself and Mr. Rainey. And because of that overlapping, the overlapping nature of the case, Mr. Rainey and I, and this is in the transcript, you can read it, Mr. Rainey and I divided up the various topics to avoid unnecessary duplication. Mr. Rainey assumed the task of addressing the significance of the correspondence between shipping and forests, whereby shipping asked forests for approval before issuing the LOIs and discharging the cargo. And his submissions on that, which are accepted in paragraph 63, 4 are important, and if I may, they're quite short, but they're significant. I would like to show them to you, if I may. They're in Supplemental Bundle 2 at tab 72, page 502. So it begins, my Lord has page 502, which is the transcripts in the typical format of 4 individual pages. And what I'd like to direct you to is the page 52, which is the page in the bottom left of the A4 sheet, and to line 16, where Mr. Rainey says, lastly, in terms of the evidence, and as I said, I'm leaving over to Mr. Bailey the accounting and monies up and monies down part of the story, so I dealt with that and other points, but it is the correspondence between shipping and forests as to the LOI. Significant reliance is placed upon this by the claimants. And then, and there's no time, and it's not an efficient use of my time to read it all, but the relevant submissions I rely upon go from page 52 of the internal pagination at line 16 through to page 504, so two pages over, to line 7 on internal page 61. Was that? I would invite you to read that passage, but what I want to do is pick up.
So you don't want us to read it now?
Well, I'm very happy for you to read it.
Well, I mean, you can tell us if you want.
Yes, no.
What you get from it.
Well, I certainly will be doing that, but I'm very happy for you to read it now. It's not particularly long, and I think it's helpful. When you get to page 53, I want to point out there's one, what I would submit as a typo at line 23 on page 53, where the judge says the sellers are effectively, and it says using the security of the goods by discharging the goods against a letter of indemnity. In my respect for submission, what he said there is losing, not using.
Yes, the essence of the submission is in the passage at the bottom of page 60, isn't it?
My lord, yes, and indeed the other passage I was going to draw your attention to is beginning of the last line of page 58 on 503. Again, there the concern is not, quote, "We do not have any authority to issue LOIs. Can you please authorise us to issue an LOI?" Close quotation mark. It is. We're going to issue an LOI, but the payment situation is unclean, and therefore you need to give us clearance as to the timing of the LOI that we are issuing. And the key sentence in the submission is it does not impact at all on what shipping are doing for their own account. And then, as my lord has already said quite rightly, the essence of the submission in paragraph page 60 is that when you look at the run of documents, what they amount to is shipping saying we wish to issue an LOI on your behalf. Sorry, it's not a situation where shipping are saying we wish you a LOI on your behalf, please authorise us to do so. What they're saying is we are shipping people, we're going to be issuing the LOI, we are the charterers, we'll be issuing the LOI, but we can delay issuing the LOI given the state of the LCs. If you want us, what do you want to do? Now,
can I ask a really basic question, just to clarify this in my mind? There's obviously a link being made here between whether the LCs are in place as to whether an LOI can be issued, and the worry is the LCs aren't in place. As the shipper, and let's say shipping was, for the sake of argument, an agent. It's obviously only an agent in relation to shipping. It's not acting on the actual sale. That's not suggested.
No.
Is it?
Well,
the LCs relate to the sale,
yes,
don't they? They relate
exactly.
to the provision of the sale price. So what's going through my mind is what's shipping's interest, if you like, in the LCs.
There's a lot to unpack out of my lady's thought, but let's assume that you start on the basis that the SSA's services, they're defined in a way that only include shipping, they don't include sale contract.
Yeah.
And then, taking up my lady's point, you look at the LCs, they're to do with the sale, not really the shipping. I mean, that's another way of looking at it, and that's a very sophisticated way of trying to square points. My submission is a much simpler one, and that is that what the approval process demonstrates is the charterers as principal, not as agent.
I suppose I'm trying to understand your submission. Maybe I'm going into too much detail to do it, but from a pure shipper's point of view, what's their interest in?
Well, my lady makes a very good point, which could square the circle, because you could say, well, even if shipping were acting as an agent, the scope of their authority didn't relate to the issuing of LOIs, which concerned the sale contracts rather than the shipping.
Well, yeah, I'm not so much making their point as rather that it's the exporters who have most the interest in whether the LCs are in place.
Quite. That's what forests don't forget, are the beneficiaries under the LCs. They're the party receiving the funds. They're obviously acting on my client's behalf.
Yeah.
And their interest is in the LCs. That's
indeed. Well, forest / the exporters.
Yes, quite. And that, as I say, I mean, I can obviously make those Mr. Rainey's submissions myself, but it seemed more efficient to simply show you what he said and I adopt it. But what it leads to, in my respectful submission, is when you look behind the judgment, if there is any imperfection in the way in which the lone judge below expressed himself, that imperfection actually lies not in paragraph 74.1, possibly in paragraph 63, but not making it clear when he said, I'm accepting Mr. Rainey's submission, that what that meant was that he was concluding, as he restated it in 74, that shipping issued the LOIs not as agents, but as principals for their own account.
The only basis for the argument that there was authority from forests to shipping, constituting shipping agent, was this correspondence.
My lord, yes.
So what the judge is doing is providing a reason for the correspondence that is inconsistent with the agency.
Absolutely. That's the precise way of expressing what the lone judge did. And what we would submit is that when looked at fairly, there is no logical flaw, except, as I say, if there is an imperfection, one with the benefit of hindsight might say paragraph 63 could have been more clearly expressed. But the key point is that there is no inconsistency of logic between paragraph 63 and 74. And as a result, there's no basis properly we would submit to disturb the judge's finding on this issue. Now, I do have an alternative submission I want to make, which is this, that even if you're against me on that, you accepted my own friend's point, well, 74.1 is a bit odd. It refers to a finding which isn't explicitly made previously. That's a logical flaw. I mean, assuming if you accept that, what does that mean? Well, it means you have to ask the question de novo, so to speak. You have to ask the question yourself. And if you do so, my respectful submission, it still leads to the same answer. And there are 4 points I want to make in support of that submission. The first is this, that I adopt, in this context, Mr. Rainey's submissions as to what the correspondence revealed, and put my case, if I may, by adopting the way in which my Lord Justice Zacaroli encapsulated it a moment ago. That's my first point. The second point is this, that if I'm right about the commercial purpose of shipping's very existence, which was to ring-fence the risks inherent in chartering without recourse to exporters, it's implausible, in my respectful submission, that Forrest would have authorised shipping to have issued the LOIs as agents for my clients as principal or undisclosed principals, which by definition would expose my clients to the risks inherent in issuing such an LOI as a charterer. Thirdly, if, as we submit, the lone judge was right on ground one to conclude that shipping chartered the vessels as principals, we would respectfully submit it's implausible, defies commercial logic, that shipping would have suddenly decided to swap hats and issued an LOI under the charter party, which provides that it's for the charterers to issue an LOI with a different hat on, acting as agent. That's, we would submit, implausible. And the final point is this, that the reason shipping issued the LOIs is because of the chain that originates from the buyers, that's Ambrose. It's not a request by my clients as sellers to issue the LOIs. The request or the impetus for the LOIs originates from the buyers. And just to make that good, show you one or two documents. Supplemental Bundle 1, just to show you the way the date, the chronology works. Taking the Harmony vessel first, go to page 171 of Supplemental Bundle 1. Now this is the Ambrose are the buyers. This is the Ambrose letter of indemnity. It comes, they're at the bottom of the chain, it comes upwards. So it's addressed to TPT shipping. And the important point is it's dated the 5th of December. So the buyers are asking shipping, who are the charterers, to deliver against the LOI because there's no bill of lading.
Sorry, I thought you said page 171. What page is it?
171? Yes, 171.
No.
Do you not have 171?
Maybe I'm looking at...
I'm so sorry.
There's different numbering and I was looking at the wrong set of numbering. My fault.
No, not at all. I'm sure
no, it's all right.
So it's page 171, my lord. It's the LOI from Ambrose, who are the buyers, dated the 5th of December to TPT shipping. And then then the corresponding letter of indemnity issued by charterers is at tab 8 of the same bundle, page 111. And as you can see, that's issued the next day, 6th, by TPT shipping up the line to Berge, and then Berge issue a similar letter of indemnity to the head owners, and ultimately the cargo is discharged before the documents arrive. And the same dates, it's the 15th and 16th, the same dates apply to the index case. Now, the reason it's the receiver or the buyer who makes the request for discharge against the LOI when the bill of lading has not arrived, is because it's the buyer under the sale contract who's ultimately responsible for demurrage. This is important because I want to show you, because my own friend says, oh, this is all for the benefit of exporters, you know. They're the party it's benefiting. The reality is, if we look at the sale contract, they're all in the same form, the topic. The relevant document is page 99 to 100. And particularly the requirements of or the terms of the contract of sale are set out on page 100. And the key, the discharge terms, 2,750 jazz per day, various abbreviations. And then the key point is under demurrage and detention, the buyer is responsible for demurrage or detention charges. And then you have demurrage dispatch, US dollars 11,500 per day pro rata, demurrage half dispatch. Now, of course it's true, we've seen this, that as between shipping and the exporters through forests, there was a wash-up whereby demurrage and dispatch were taken into account for the purpose of working out the net costs of carriage. We've seen that. But the reality is the party truly at interest in having the cargo discharged without the documents, the party who initiates the request for the LOI, is in fact the receiver, the buyer, and not the exporters. My client's only real interest, as my lady had said, is in relation to the letters of credit and security that the goods represent for the payment of the price. That's their interest. So against that background, when you look at my own friend's Mr. Rainey's submissions, you look at the requests themselves that emanate from shipping, it's clear in my respectful submission, as Mr. Rainey submitted, that forests are not authorising the issuance of LOIs, they're simply approving them. And perhaps just to make this clear, we'll just take one example, which is the Cosmos Harmony. And if we start by looking, if I may, at Supplemental Bundle 1, and beginning, if we can, at tab 26, which is page 214, and in the middle of the page, there's the email from TPT Shipping Operations to Jason Smith, who's the Director of Shipping, and also to Andrew Essen, who you can see has a Forest email address, dated the 2nd December. Hi, Andy, Jason, can you please approve to issue following LOI? And Andrew Essen says okayed at the top. And what I want to draw your attention to is in the bottom box, buyer Amro's contract value, and then the key part is documents are clean. So, okayed. Now, let me move forward to the 5th of December, 216.
Sorry, what do you say you get from documents are clean?
Oh, that means the LCs are in place and there's no difficulty in delivering, there's no problem to the security because the LCs are in place. And then if you go to page 216, correction, we see a correction coming. So, hi Andy, correction on below. Roland advises that there are actually still one LC outstanding, waiting for LC for 957K. I need to issue tomorrow. Can you please approve that I can issue even with missing LC? So it's odd, isn't it? I mean, the okayed came 4 days earlier. If that was the authority to issue, well, they didn't need to go back and ask again. The reason they went back and asked again is not for a reaffirmation of some sub-agency authority. It's just a legal, makes no sense in interpreting what was commercially going on here. What they went back for and asked again is not for authority, for approval in light of the fact that they needed to correct the situation because the documents weren't clean and there's one LC missing. And then finally, if you go to page 226, so we're getting later in the day, now we're getting to the 9th of December. Still missing, still waiting for one LC to come through. You see that at the bottom of page 225. The response from Forrest at that time is okay to go ahead, but please run the LOI past Jason before sending out. Also, thanks. And Jason is a reference to Mr. Smith, who was the director of shipping.
Sorry, where are you reading from?
Page 225.
Oh, okay.
The very top is the last email that gives final approval, notwithstanding that it comes 5 days later, notwithstanding the fact that one LC is missing, they do approve it. But what the correspondence reveals in my submission is that the concern is about the LC. It's not a request for authority in any agency context, suggesting that either shipping or forests understood that what was being asked for is for permission to issue an LOI in the name of charterers, but as agents for undisclosed principles, binding the exporters to those LOIs as parties. That's not, in my respectful submission, what the correspondence reveals, and the learned judge's analysis, evaluation of it was, in my respectful submission, correct. So even if, and this brings me to my conclusion, even if you were to conclude that there were a logical flaw in 74.1 in the way in which the learned judge below expressed himself, and you ask or make the inquiry yourself afresh, it still leads, in my respectful submission, to the conclusion that we have the better of the argument, and that's all that I have to establish. We have the better of the argument that shipping issued the LOIs in its capacity as charterer and as a principal, not as agent for my clients as undisclosed principals. So that's the first limb of my answer to ground 2 of the appeal. And it brings me, if I may, to the second limb. Now, even if I'm wrong on everything, which I've said so far, which is possible, of course, my learned friend still has to overcome the conclusion by the judge in paragraph 74, 3 to 6, that shipping had no actual authority to issue the LOIs on the exporter's behalf. And the reason for that is because the judge accepted that even if forests had been purporting to authorise shipping to issue the LOIs on the exporter's behalf, neither forests, and therefore by definition, neither shipping, had authority to do so, actual authority to do so. Now, what my learned friends say is, well, they can get round that finding, not because the judge made a mistake, or at least not one he was conscious of, but because they've come up with a new ingenious argument based on the REMCOM AGAU case and the doctrine of ostensible authority. And that argument wasn't advanced, that is common ground. 2 points of common ground which are important. Firstly, it wasn't advanced below. And secondly, and this is crucial, is that my own friend quite rightly accepted explicitly in answer to my Lord Justice Mayles that on this new argument he must prevail to win the appeal. So, in that context, 2 inquiries arise, 2 questions. Firstly, should the owners be permitted to run Mr. Berry's new argument on this appeal? And if you say yes, that's fine. They are permitted to run the argument on this appeal. Do they, as a consequence, have the better of the argument that shipping issued the LOIs with actual authority of the exporters? So those are the 2, or does the position remain as the judge found? Those are the 2 inquiries. And in my respectful submission, the answer to both is no. Now, take the too late point first. My own friend took you to the Rhine and Vitol case, which we accept is the most recent exposition of the relevant principles to be applied. Your Lordship will know that was a trial case, but there is other authority, I think it's called Rana and Ealing. I'm not going to turn it up, but I'll give you the reference. It's at tab 39 of the authorities bundle at page 758, paragraph 20, where I think it's Lord Justice Underhill said that same principles apply to interlocutory appeals. Now, the first point I want to make is this, that in my totally respectful submission of my own friend, the one point that he made yesterday, which I would respectfully suggest is palpably and demonstrably wrong, is the submission that the AJU REMCOM point involves a pure question of law. In my respectful submission, that's plainly not right. The reason it's plainly not right is because it gives rise to at least 3 significant factual inquiries. And they are, did my clients represent to shipping that forests had authority to authorise shipping to issue LOIs as agents of my clients? So that's the first inquiry. Did they make that representation? The second inquiry is, did shipping believe that representation, or did they know about the limitations on the scope of Forest's authority? And thirdly, the third major factual inquiry is, did shipping rely upon the representation and intend to issue the LOIs as agents for my clients? Now, none of those, it's true to say some of the evidence could be said to bear on those questions, but the point is none of those questions have been addressed, at least not directly, in the evidence before the judge below. And that's important given the way Lord Justice Popplewell expresses the test in the Rhine case, the relevant key paragraphs being paragraphs 23 to 31 of that judgment. So in my submission, there are 2 key reasons why permission should not be given to run this new point on the appeal. And the first of those submissions is this, that had it been run below, it would have completely changed the dynamic of the hearing before the judge. And the second reason is because had it been run below, there is a real possibility that had the point been taken, additional evidence could or would, and that's the only requirement there is to show, could or would have been adduced that had a possibility of affecting the outcome. So just to develop those points briefly, in terms of the dynamic, Forests accepted before the learned judge that they had never sought and never obtained authority from the exporters to authorise shipping to issue the LOIs on the exporters' behalf. Now, if owners had been running below the argument, the Forests nonetheless still had ostensible authority to bind exporters, that argument, if successful, and the same is true on this appeal, that argument would have exposed Forests to a potential liability to my clients for acting in breach of their authority when purporting to authorise shipping to issue the LOIs. And that would, in my respectful submission, have had a substantial impact in this sense. Firstly, in the absence of Forests, if this court were to entertain the argument on appeal and it were to succeed, then my clients might be liable to the owners, but they'd have a claim over against Forests. And if that's right, we would submit that it's unfair, at least to Forests, to raise the point in their absence. And perhaps more importantly, had it been run below, one can reasonably and properly infer that Forests would almost certainly have adduced evidence on it, particularly on the question as to holding out and representation, and particularly on the question as to what shipping knew through Jason Smith, the director of shipping, who at one stage was also a director of Forest, what shipping knew about the extent of Forest's authority. And related to that, on the question of reliance by shipping itself. And the further point is, I don't want to put this too highly, and I don't want to put this unfairly, but what I would submit is that if the point had been run below, it is at least plausible that my clients would have wanted themselves to adduce evidence on the factual question as to whether they made a representation holding out forests in some way. And it's perfectly possible that my clients would have sought to at least interview Mr. Smith in relation to the question of reliance. I don't want to put that too highly, but objectively speaking, those are reasonable inferences as to what might have happened below had the point been run. So for all those reasons, we respectfully submit that it's too late to run it now. But anyway, I then come on to the substance, which is, of course, also of crucial importance. And the substance of the submission is this, that even if you were to allow the argument, the new argument, the AJU or the Remcom case argument, to be run, it doesn't assist the appellant. And I've got five submissions to make as to why that is the case. And the first submission is this. As my own friend accepted in answers he gave, particularly to my Lord Justice Zacaroli yesterday, AJU was not an undisclosed principal case. And there is, and my own friend accepted this, there is no authority which bridges the gap or bridges the divide, I think as my Lord put it. Against that background, my learned friend's burden in my submission is a heavy one, particularly given the clear statement of legal principle stated by Lord Lloyd and many other eminent judges, to the effect that the undisclosed principle doctrine can only apply if the agent has actual authority. And the findings, obviously, of the judge below, that neither Forest nor Shipping had actual authority to issue the LOIs on exporters' behalf. So it's a heavy burden. The second submission is this, that if we look together at the Remcom case, and it's in Authorities Bundle 2 at page, tab 31, page 563. It's paragraph 18, and I think the page numbering may have been obliterated slightly, but it's page 563 of the bundle, my lord. So paragraph 18, it seems to me that where an employee acting within his ostensible authority gives instructions to a broker who makes an agreement with a third party in reliance upon that ostensible authority, the broker has actual authority to make the agreement in question. As against the broker, the principal is stopped from denying the employee's authority, with the consequence that the broker acquires actual authority to act. My second submission is this, that the second sentence of that paragraph explains the first. And what I mean by that is the broker doesn't acquire actual authority, rather the principal is stopped against the subagent from denying the authority of the main agent. And the reason I say that is because the key words in my respectful submission in the second sentence are, as against the broker, the principal is stopped. Now, in my respectful submission, there is no basis or reason why the principal should be stopped as against the third party, in this case, the owners, who are not privy to any representation. They have no benefit of any equity, and they only bargained for the liability of the agent. So there's quite a lot in that, and I hope I've made that clear. But that's my submission to why the estoppel shouldn't operate to prevent what I can say against the owners, even if it does, and what I could say against shipping. The third submission, which is related to that, is that the rationale for the AGU principle is not engaged where the principle is undisclosed. If I can try and explain that, it's a reference really to what Bousted and Reynolds say in paragraph 5105, which is in bundle A3, tab 53 of the bundle, at page 1347. If you remember yesterday, we looked at this with my own friend, 1347, and there was a reference to 109 and the footnote, which has AJU. There's another case, we've all looked at it, and it doesn't seem to say anything about this particular point, but there it is. It's AJU or nothing. Anyway, being that as it may, it's the passage I want to refer you to is this, after the footnote. The basis for this result seems to be the justice of the sub-agent's position. The sub-agent should be able to rely on the head agent's apparent authority, lest the sub-agent become liable to the third party in breach of warranty of authority. And that's what Peter Watts says is the rationale or the basis for the so-called AJU proposition of law. Now, in my respectful submission, that basis, that rationale, can only apply where the sub-agent purports to contract qua agent for a disclosed or an unidentified principle. In other words, where the agency is disclosed. And the reason for that, and there's no doubt about that, the reason for that is that an agent for an undisclosed principle gives no warranty of authority whatsoever. By definition, gives no warranty of authority to the third party. So the rationale doesn't apply. Now the fourth reason is that the doctrine of whatever other anomalous features it has, and there are too many to go into, and for another day there's the argument about whether we should be following suit of various other common law jurisdictions that have abolished it altogether, but that's not my case today, certainly. But we are in a situation where, whatever its anomalous features may be, one key aspect of the doctrine of undisclosed principles is that it's mutual. And the clearest authority for that proposition is the judgment of Lord Sumption in the Playboy case, which is in the bundle of authorities A2, tab 37. Page 736. Paragraph 15, top of page 736. Thirdly, the appellant submission would require one to import into the law of tort just one aspect of the law relating to the undisclosed principles. But in fact, the law in this area is a complex bundle of interrelated rights and liabilities, most of which are entirely inapposite to the law of tort. And then it's this sentence, or the next two sentences. The relationship between A and B's undisclosed principle may not be consensual, but it is at least mutual. The undisclosed principle may not only sue, but be sued on the contract. Now, what does that mean? What's its significance here? What it means is that if there is a contract which my clients are said to be undisclosed principles, then we have as much a right to sue on that contract as the third party has a right to sue us. And the fundamental difficulty is that the AJU principle cannot be properly rationalised into the concept of mutuality. And the reason I say that is twofold. If the AJU principle was applicable to the doctrine of undisclosed principles, it should mean, therefore, that when the scenario applies, my clients as undisclosed principals would be entitled to sue on the LOI or whatever other contract it is that has been entered into on that basis. That's what the concept of mutuality would require. But in my respectful submission, that cannot work for at least two reasons. The first is this, that the undisclosed principal cannot rely upon an estoppel against himself as a basis for founding a cause of action on a contract which he is not a party. When I say that, I mean not a party other than by reason of proving he's an undisclosed principal. That's the first reason. The second reason is that in my submission, the principal cannot create actual authority by estoppel any more than he can create actual authority by ratification. And the reasons why an undisclosed principal cannot create actual authority by ratification were explained by the House of Lords in Keeley and Maxted against Durrant. And again, it's a case we haven't looked at, it's in the bundles at bundle A1. At tab 8. And the headnote, despite the length of the case, the headnote is extraordinarily concise. Page 126. A contract made by a person intending to contract on behalf of a third party, but without his authority, cannot be ratified by the third party so as to render him able to sue or liable to be sued on the contract, where the person who made the contract did not profess at the time of making it to be acting on behalf of the principal. So what we get out of that is the fact that in the first line, even though the person is intending to contract as agent, unless he discloses that fact at the time of contracting, ratification is not possible. And there are a number of judgments, and they all basically put the same point in different ways. And I'm going to show you, if I may, as the principal exemplar of the point, what Lord McNaughton says. We put red lines against particular passages, which will help, but if I can show you the couple of paragraphs that are helpful, the time I have. I start with Lord McNaughton in page 132. As a general person, only persons who are parties to a contract, acting either by themselves or an authorised agent, can sue or be sued on the contract. A stranger cannot enforce the contract, nor can it be enforced against a stranger. That's the rule, but there are exceptions. The most remarkable exception, which is, of course, the doctrine of undisclosed principle, which results from the doctrine of ratification. Sorry, just ratification, quite right. Minor offence, quite right. Ratification. That's another remarkable one. That doctrine is thus stated by Tyndall in Wilson, that an act done for another by a person, not assuming to act for himself, but for such other person, though without any precedent or authority whatsoever, becomes the act of the principal, if subsequently ratified by him, is the known and well-established rule of law. And it goes on, in that case, the principal is bound by the act, whether it be for his detriment or advantage, and whether he founded on tort or contract, to the same effect as by and with all the consequences which follow from the same act done by his previous authority. And so, by a wholesome and convenient fiction, a person ratifying the act of another, who without authority has made a contract openly and avowedly on his behalf, is deemed to be, though in fact he was not, a party to the contract. So what he's referring there to is what he describes as a fiction, and how the fiction results in a deeming. And I pause to say that because, in a sense, the estoppel which my own friend relies upon, is of a similar nature. And then Lord Macnaghten goes on, does the fiction cover the case of a person who makes no avowal at all, but assumes to act for himself and for no one else? If Tyndall C.J.'s statement of the law is accurate, he would seem to exclude the case of a person who may intend to act for another, but at the same time keeps his intention locked up in his own breast. For it cannot be said that a person who so conducts himself does assume to act for anybody but himself. But ought the doctrine of ratification to be extended to such a case? On principle, I should say certainly not. It is, I think, a well-established principle in English law that civil obligations are not to be created by or founded upon undisclosed intentions. Now, of course, I appreciate that that case is not dealing directly with our situation, and I only rely upon it by way of analogy. But what I would respectfully submit is this, that the essential reason why ratification does not apply in the context of the undisclosed principle doctrine is because, by definition, the intention to contract as agent is undisclosed. And we say the same result applies when one is seeking to rely upon an estoppel to effectively create actual authority when none existed, because the reliance is undisclosed to the third party. And I say that because there is no, by definition, the agent makes the contract in his own name, he doesn't disclose the agency, and therefore the reliance remains undisclosed, just like the intention to create a contract remains undisclosed in the context of ratification. So that's where the parallel exists, and the same rationale, in my respectful submission, applies in the case of the AJU principle. And then fifthly and finally, in my respectful submission, we would submit that my own friends' clients can't actually satisfy either of the AJU requirements of representation and reliance. And the reason I say that is because, in my respectful submission, there is no plausible evidential basis for the submission that exporters held forests out as having authority to issue LOIs, whatever else authority they may have given them. They didn't give them authority to issue LOIs on the exporter's behalf. No representation to that effect. And then secondly, there is no plausible evidential basis for the submission that shipping relied to its detriment on some unidentified representation that exporters had made. And the reason I say that is because if I'm right about their purpose, shipping, their commercial purpose, ring fencing, the role it was playing, shipping would have no reason to be relying upon a representation for the purpose of binding my clients as parties to an LOI. And the reason for that is that they sought their security, their recourse, as we discussed yesterday with Lord Justice Zacaroli, their recourse was in the form of the LOI from Ambrose. They didn't commit, I'm not going to go back over the wording, but they didn't commit, as my own friend put it, commercial suicide. What happened was Ambrose became insolvent. It was a result of that insolvency that shipping was unable to collect on the LOI. That was the chartering calamity. That was the chartering risk. And that was what was ring-fenced. It was an unfortunate loss as a result of Ambrose's insolvency. But that was the chartering risk that was ring-fenced within shipping. My own friend says, well, the ring-fencing was only for shipping, TPT's group's benefit, but that makes no sense, particularly since my clients were told expressly in a letter about the ring fencing. But it was no concern to us that we wouldn't have been told, but we were, and we were told there was no recourse. And that was because that was the commercial purpose and the understanding between the contracting parties of what shipping's role was. And therefore, in my respectful submission, the idea that they were relying upon this representation in issuing the LOIs is actually inconsistent with the weight of the evidence.
What would the reliance by shipping have to consist of? It can't be that they won't be liable under the LOI, because they will be, even if they act as agents for exporters as undisclosed principal. But it would have to be, I suppose, that they did it because they thought they would have a right of recourse to exporters in the event that the LOI was called upon. So there would need there to be evidence that that sort of thought process went through somebody's mind.
Certainly a thought process would have gone through somebody's mind which was not disclosed to anybody. But, my Lord, my submission, the most obvious form of detrimental reliance would have been shipping say, I'm sorry, I'm not going to issue an LOI without having full recourse by way of some agency indemnity from exporters. They went ahead and did it. We say not by way of any reliance, but if they were to try and prove it, they'd have to show something in the mind of shipping which wasn't disclosed to anybody as to what was going through their mind at the time. And that's why we would come back into the ratification issue, because that was exactly the problem with why ratification shouldn't apply to the doctrine of undisclosed principles. Because it opens the whole situation up to a possibility whereby, not suggesting that's this case, whereby the principal and the agent after the event can get together and simply say, well, you know, I know you didn't say anything to anybody else, but as long as you say you intended to do this on my behalf, that's good enough. And that's the problem that the House of Lords said in our objective process of contract. I accept, of course, undisclosed principles is an anomalous doctrine in that context, but nonetheless, to add a further anomaly to it, to pile anomaly onto anomaly, would be wrong. So I hope I've answered my Lord's question. I've rambled a little bit there, but I hope I've tried to capture it.
Yes.
Now, my Lord, unless I've got any questions I can assist with, those are my submissions.
Thank you very much indeed. Mr. Berge.
Thank you, my Lord. My Lord, can I first remind you of what constitutes a good arguable case in any context where you can't reliably take a view on the question in issue, and that is that judgment, in the judgment of the judge below at paragraph 14 from the Clifford Chance case, and or at page 151 of the core bundle. And my learned friend repeatedly cited the test as expressed in 79(1) of the Clifford Chance case, quoted in paragraph 14 of the bundle, which is evidential basis, showing it has the better of the argument, not much better. But that is qualified by 2 and 3. If there's an issue of fact about it, or some other reason for doubting it, the court must take a view if it can reliably do so. So, fact or law, you must be able to take a reliable view. And then 3, the nature of the issue and the limitations of the material available at the interlocutory stage may be such that no reliable assessment can be made, in which case there is a good arguable case for the existence of the agreement if there is a plausible, albeit contested, evidential basis. So in the interlocutory stage, in any case where a reliable view cannot be taken on the facts and law, then the actual test is a plausible, albeit contested, evidential basis. And that is, in my submission, the true test of what a good arguable case is, if I'm right in saying that you can't reliably take a view on a number of the issues. Well, I say you can reliably take a view in my favour, but at any rate, you can't reliably take a view against me. Secondly, my lord, the flaw in the judgment is obvious, is very obvious. 74.1, at page 170 of the core bundle, a learned friend tried to save this by reading back into the submissions, but we will see which part of the submissions or how the judge understood the submission. 74.1, I have already found that forests have the better of the argument that the LOIs were issued by shippers on their own behalf. No, he had not. In 63, what he found on this issue was only that, notwithstanding there was a system whereby forests were asked for their approval before LOIs were issued by shipping. And so that system of asking for approval, it is to be inferred, would have counted as authority and would have supported an agency, except for the however. And the however is, I do not consider that this justifies a conclusion that forests were indicating consent to be bound and liable on the LOIs. So that is purely a finding, not forests. And it cannot be teased into or twisted into a finding, not forests, yes, shipping as principle, by the silken advocacy of my learned friend. He looks at subparagraph 4, and then he goes back to Mr. Rainey's submissions and reads extensively from what Mr. Rainey submitted. But what matters is what part of Mr. Rainey's submission the judge accepted here. And the part that Mr. Rainey, of submissions that he accepted, was an obvious reason, which is that the goods represented security for the payments of goods. When those goods were discharged, that security would be lost. That is the only part of Mr. Rainey's submissions that the judge accepted. But that supports agency for exporters. That particular submission says it's exporters who had the say-so as to whether to release the goods because it's their security. So the only part of the submission that supports the not forests is that this particular point, it was exporters' security, points to exporters. And that is as much as to say that 4 is of a part with 5, which is the interest in demurrage and dispatch, being that of exporters. So what he's saying here in 4 is that the party really at interest was exporters. And that's why forests, who were agents for exporters, would want to be consulted. I.e., the party who has the say-so to release his exporters, and forests, as their agent, obviously need, therefore, to give the say-so on behalf of exporters, as they always act. So really, there's a fundamental flaw there, because far from finding that it was issued by shipping on their own behalf, the reasons why he found that forests had the better of the argument that it was forests were not principal, were all reasons for exporters being principal. And that is, in my submission, a flaw, however it's done. Now, my learned friend then, I'm now addressing the question, so that's flaw, and I've made submissions. I'm now going to address the question of whether shipping purported, objectively as we see is the test, to act as agent for forests, which means exporters, and therefore exporters. And, my lord, our primary case is that the 2012 agreement provides for shipping to provide services for and on behalf of the export clients. For and on behalf of is the phrase. For reminder's sake, it's clause 5.1 at page 69 of tab 4 of the authorities bundle.
Supplementary.
Sorry, the supplementary bundle. Beg your pardon, yeah. TPT shipping shall provide the services for and on behalf of the export clients. And my learned friend showed you the Rochdale case. But my lords, my submission on that is that the Rochdale case is that the words on behalf of on their own do not necessarily connote agency, because on behalf of may sometimes only mean for. But that is impossible in the phrase for and on behalf of. And so I'm very grateful to my learned friend for the Rochdale case, which shows that for and on behalf of can only mean agency. And if we can go to the Rochdale case, it's at, I don't know how your lordships have it, but it's at 1353 of the report in the PTSR. Some kind of post-traumatic stress reports. And if you look at paragraph 49 at 1353, and the concept of agency is inappropriate invoked in the analysis of these arrangements, there is also authority that the expression on behalf of does not necessarily require the concept of agency, but may have the more general meaning of for the benefit of. So on behalf of on its own may mean for, but for and on behalf of, you've already got the for, the on behalf of can only connote agency, in my submission. And of course, that's what Lord Justice Ricks accepts in 50. Those conclusions seem to correct to me. Indeed, I would include the simple preposition for as one of the possible meanings. But if for cannot be one of the possible meanings in for and on behalf of, because that would mean for and for, which is nonsense. This is conclusive in my favour as to the express agency, and so I'm grateful for that. Now, Magellan, my lord, and my submission on Magellan before I go to it is that Magellan was a case of back-to-back internal charter parties. And that is fundamentally different when there is no back-to-back internal charter party, and the only possibility for a contract between the sub-agent or the agent and the principal is an agency. Sorry, the name charter and the principal is an agency. And that, my lord, is in Magellan, which is tab 34 of volume 2. And my learned friend showed you page 642 and 643 in the judgment of Mr. Justice Leggett. Can I identify the parts that matter? Paragraph 31. It's clear from the evidence that the purpose of chartering the Magellan Spirit was solely to carry cargoes bought and sold by Vitol, no intention to try and make profit, and so on and so on. It went without saying that the vessel would be operated at cost, such that Mansell would be reimbursed by VSA for costs and liabilities. So there's what I would call an indemnity against liabilities between Mansell, the equivalent of shipping, and VSA, the equivalent of forests, who are obviously exporters. And the evidence confirms that this is indeed how the vessels operated in particular. The vessel was recorded in the Vitol Group's internal records as relet by Mansell to VSA at cost. And relet is a well-known thing, my lord. There is an internal back-to-back charter party between Mansell and Vitol. But here, there is no possibility of that. There is no internal record between the Vitol company and its subsidiary Mansell saying, between exporters, stroke forests and shipping saying, relet the Cosmos Harmony. There's no back-to-back charter party, and it is necessary, therefore, in my submission, to imply agency, because you can't imply a complete new charter party between the two, or at least of the two implications necessary to avoid the sacrificial lamb position, which I'll come to in a minute. It's agency that's required. Magellan Spirit is fundamentally different because it's principal to principal subcharter, or relet charter. Now, my lord, on this point also, my learned friend pointed out or said that the interest in issuing the LOI was ultimately that of Amrose, because Amrose agreed to pay demurrage stroke dispatch. But as with the rest of his submissions, my learned friend has not dealt with one of my headline submissions, which is that the accounting of address commission and dispatch is consistent only with agency. I mean, it would be consistent with a back-to-back internal subcharter, but there's no, he doesn't suggest that, and that's not, it's harder to imply a whole charter party than to analyse it as agency under section 5.1 of the agreement. I won't say agency agreement, although that's what Shipping called it. So, and that's relevant to paragraph 33 here. One can understand reimbursement at cost, but one cannot understand the actual payment over of address commission and dispatch as a reimbursement at cost. My learned friend says, oh no, you net it off against the demurrage, but there were actual credits, positive credits of dispatch. And legally and analytically, it's sloppy thinking to say it's just netting off. That's true of every payment. Payments are always netted off. There's one higher payment at the end of a voyage charter. But one needs to analyse what is happening in substance. And what's happening is that money is going to exporters, not explicable except in my submission as agency. Now, still on the question of whether they purported to act as agent, my learned friend's submission really does come down to, and he has to be right about this to be right at all, that the intention, certainly of his clients, was that shipping be put up as a sacrificial lamb. He may say that in this case, not so, because in the LOI case, before your lordship, he got a cross indemnity from Amrose, but we've already submitted that a cross indemnity from a Singapore private company for export of logs to India is likely to be and was worthless, as it proved immediately when called on. So I submit the Amrose is no proper comfort to anybody, but even if that's wrong, as my lord Zacaroli pointed out, it's not just letters of indemnity that you are exposed to when chartering. Losses are not confined to losses on indemnities. The obvious one, which I might have muttered under my breath, but I shouldn't have, is dangerous cargo. Let us hypothesize, not an unlikely hypothesis, because logs have been known to spontaneously combust and burn a ship, that the cargo is dangerous, dangerously wet, explodes, burns a ship. Then shipping as charterer is liable for shipping a dangerous cargo. And that's the kind of disaster that at least is encompassed by the ring fencing idea in case of shipping disasters. And so I would say for letters of indemnity also, but for all the massive liabilities that a charterer can and does take in a voyage charter, that either they are a sacrificial lamb with no right of recourse against anyone, because there's no back-to-back internal charter, as in the Magellan Spirit, or there has to be an agency, because it is commercial suicide otherwise. Sacrificial lamb, commercial suicide are the same point. And for my learned friend to be right, you would have to hypothesize.
Why wouldn't the shipper be liable to them if there was dangerous cargo.
Well, on the bill of lading.
Well, they're not parties to the bill of lading, it's an owner's bill, but there'd be
Quite.
at least a right of contribution.
Well, there may or may not be a right of contribution, which may or may not be worth something. But the point is that the charterer, on this hypothesis, shipping would be in the front line for the dangerous cargo claim from the disponent owner.
Well, actually, it would be exporters in the front line from the head owner, whose ship it is,
Under the bill.
damaged, under the bill of lading.
Well, there'd be two.
So it would be exporters, in fact.
There'd be-
It would be on the line. For
There would be
dangerous
two
cargo.
front lines. The charter party and the bill of lading.
Yeah.
Shipping would be jointly in the front line. They'd be standing there together like the Spartans at Thermopylae, shoulder to shoulder. Why would shipping do that without indemnity against exporters? Obviously, there may in New Zealand be rights of contribution, but that's a far lesser possibility than a simple right of indemnity under an agency. And there may be other liabilities as charterer. I can't think of one exactly at the moment, but there are likely to be other liabilities as charterer that are not, in respect to which there's no liability under the bill of lading, because the liabilities on the bill of lading are not necessarily the same as under the charter, although if there's incorporation of the voyage charter, as there often is, they may be subject to the Hague rules about the same. But my point, my lord, is that there are huge liabilities being taken by shipping, and if the ring fencing is to be taken seriously, the intent was that exporters would not be liable on the bill of lading.
Doesn't that just merely restate what ring fencing is? I mean, that was the whole point of ring fencing, that there were potential liabilities which exporters wished to be insulated from, on their case.
On their case, in my case, it's forests and the TPT group that yes,
But
it does.
on either case, that you're merely describing the consequence of ring fencing.
I am.
Yeah.
The point goes around itself. You're right.
So where does it take you?
That point doesn't. But my lord,
And even forests are not ring-fenced because they are the named shippers in the bills of lading. So they are liable for whatever are the liabilities of the shippers, whether for putting dangerous cargo on board or anything else.
yeah, but the ring fencing that was professed was ring fencing against chartering liabilities. They didn't try to ring fence against liability as a seller or liability as a bill of lading holder, just specifically chartering liabilities, as I recall. We'll go back to that so ring fencing. So my learned friend's case and my case on ring fencing is ring fencing against charterers' liabilities, and they are not coterminous with ship owners' liability, with bill of lading liabilities. My lord, one example is perhaps is stevedore damage, or stevedore damage before loading. Now, that may depend on whether the bill of lading incorporates those provisions. But for example, in the wash-up, I can show you supplementary bundle, volume 1, tab 39, page 260. 260 is that volume 1 or 2? Volume 2 then, sorry. One sees that in this wash-up relating to the vessel Denser Leopard, and if one goes back to the previous page, one can see that that's a 2014 voyage. Denser Leopard voyage 14519. By way of explanation on the damages been sought by owners against shipping on the MV Denser Leopard, while the vessel was discharging at Mundra, the stevedores damaged the hoisting wires and refused to work the vessel. Shore cranes were hired to complete discharge as the stevedores refused to work. The summary of the costs is as follows, and then there's a cost for a certain amount of hoisting wires per jazz and shore crane rental and the like. Under our charter party, the owners are claiming this amount and time loss from TPT shipping as the entity responsible for the stevedores. So stevedore damage is a well-known phenomenon, and that's a chartering risk, not, in my submission, likely to be covered by a bill of lading, certainly before the cargo is lifted on.
What's your point here, that charterers bore that risk in this case, bore that cost?
Yes.
In this case? So they did. They worked it.
Well, we don't know what happened to this particular incident because it's, if you see a little bit lower, this is the original estimate, the inventor's in dispute. So there was a stevedore damage dispute between the charterers there and the ship owner.
So this isn't shipping asking for reimbursement on this?
Well, it must be, because why else are they putting it into the forest's wash-up? So there's 2 points to be derived from this. Firstly, there are charterers' liabilities, which, if my learned friend is right, they have no claim against by contribution or indemnity from the shippers. And my initial submission is that's a clumsy way of looking after yourself. But secondly, the very fact that that charterers' liability claims are put into the wash-up is evidence that there was recourse against forests and thereby exporters, because otherwise what is the point of telling forests and exporters that here's a charterer's liability which may come through? Now, we don't know, because the documents disclosed don't disclose, how much of these credits and debits were, whether they included charterer's liabilities on any of the previous cases. But the fact that there's one as yet undecided charterer's liability being put in to the wash-up that is sent by shipping to forests.
Can I just understand, you say it's put into the wash-up, that the numbers aren't being taken account in the washed-up figures?
Quite.
It's just a note in the document.
You're right.
Yes.
Commented, attached as a comment in the wash-up.
Yes.
Would be otiose unless the ultimate purpose was to, if and when that claim was settled and paid by charterers, to include it. But I cannot tell your lordship, from the information available, although ultimately it would be doable from disclosure, whether that one was ever debited to forests and thereby exporters, and whether previous similar ones, stevedore damages claims, are the ones that happen regularly, were also debited. But the fact that it's put in as a comment is plausible evidence, that being the test, that there was indemnity, or there was recourse, and the explanation was recourse is agency. And I think if you look at 257, where did it say that? Yeah, if you look at 257, the heading is charter vessels yet to be washed up. And this is in 2019, and the oldest charter vessel yet to be washed up is the last sailing date, 9/11/2014, is the Denser Leopard. And the inference from the note 2 pages on is that Denser Leopard had not been washed up because this charter damage stevedore claim, this charter stevedore damage claim was pending but was to be included in the wash-up. So that is plausible evidence of an indemnity going given to shipper from exporters via forests, and the only credible explanation of that is agency. There being no back-to-back internal charter. So that is in the same category as dispatch. It's a practice dating back to 2014 at least that is explicable only as agency. But I keep going back to the point. My primary reliance is for and on behalf of, particularly in the context of all points like this. They are independently sufficient in themselves, these points, but they are all matrix support for the interpretation of the 2012 agreement as an agency agreement. Now, ring fencing. I won't go back to the documents, but it is quite clear in my submission that at least as between internally to the TPT group, the intention was to ring fence the TPT group, and that's page 176 of the supplementary bundle. It may or may not be that forests, when informing their clients of the introduction of shipping, gilded the lily and over-egged the pudding, if the interpretation of page 177 is that you too are ring-fenced. My primary submission is that that is not what they said, but if it was what they said, then it was not an accurate statement of the true position internally to TPT. So what is relevant in this case? My Lord, where this comes into the debate is in the whether shipping purported to act as agent. And shipping, there's no evidence that shipping knew of what was being said about their role to exporters, and the evidence of the, as it were, the split in management between shipping and forests so as to avoid the appearance of associated companies is plausible evidence that they didn't. It's better than a Chinese wall. They're separate companies with separate management, deliberately so to prevent an inference of association. So, those submission on what they purported to do.
Sorry, you said Chinese wall, but you haven't actually got point to evidence that there was a Chinese wall.
I said it was better than Chinese wall, my lady, because they're separate companies with separate management structures to avoid the inference of association. Perhaps I better make that good by looking at page 176 in supplementary 1.
Yes, I'm looking at that. That's of course before, is that before TPT shipping was incorporated?
It's the first of the month and it was incorporated that month.
And doesn't Jason Smith become the director of TPT shipping? Or
He does.
I got that the wrong way around?
Smith becomes TPT shipping. So he's originally part of the TPT group generally. It just doesn't say what particular role he had.
Yes.
When shipping comes in, he's hived off, and issues to be resolved. 2, transactional management to eliminate associated party inference, and 4, transactional operational processes to eliminate associated party status. And then if one, I won't necessarily take to them, but one sees that they had different email addresses. Some were shipping and some were forests. And the inference there is that the management processes were separate to eliminate the inference that they were associated parties, which is, in my submission, well, I've described it as better than the Chinese wall. They're 2 separate companies with 2 separate managements, so you don't really need a Chinese wall because there's that separation between them. You've got an English Channel, not a Chinese wall. Those are my submissions on what they purported to do, and really it's a choice between the sacrificial lamb theory. Here was a company put up without any recourse. The only recourse being possible here is agency. To be a sacrificial lamb, to take on massive liabilities under less of indemnity against possible counter-indemnities, massive other liabilities, to be folded when the first sign of trouble, or what would be the normal situation, and the situation envisaged by the 2012 agreement, which is they were agents with an agent's indemnity. I move then on to the Remicon point. So in my submission, we had you may or may not be able to take a plausible, a reliable view, but my minimum submission is that there is plausible evidence that shipping purported to act as agent for exporters. And my maximum submission is that you can take a view that we're right about that. Second question, which I need to succeed on, is Remicon. Now, should we be allowed to argue this? My learned friend's submissions today came as a great surprise to me, because if we look at his supplementary, his skeleton, at paragraph 40, they were completely unheralded, unsupported by any references to anything, unsupported by any evidence, and frankly, McCorberism. So in paragraph 40, Berge accepts that this is a new argument not raised before the judge. An issue thus arises, as Lord Justice Mayles observed in granting permission to appeal, as to whether Berge should be permitted to raise the point at this stage. And then they refer to the authorities. Exporters submit that it should not. Berge offers no reason why it could not have taken the point below. There is none. So the only ground of resistance was we didn't explain why we didn't take the point below. Well, the point was one of those that in the welter of other points was missed. It's obvious. But he does not say, and there's no basis for saying, that any of the other requirements or any of the other triggers for not allowing a point to be taken were triggered there. So what did he come up with on his feet without any evidence, unless he's giving evidence below? He said that the dynamic of the hearing below may have changed. But my lord, that is not enough if that's just to say there would have been different argument, because the requirement is that the evidence would have been treated differently somehow. So there has to be some assertion that things would have been different. And in the Rhine case, things would have been very different because there was cross-examination, and the cross-examination would have been different if the point had been taken, and so on and so forth. The second point I would make is that whilst the principles apply to interlocutory hearings, they must apply differently than to a trial, because the result of an interlocutory hearing, as this, is the finding of a good arguable case, whereas the result of a trial is a final decision on the merits of the litigation as a whole, subject only to appeal. And
Mr. Bailey did say in his respondent statement opposing permission to appeal that none of the parties directly addressed the issue of apparent authority in the evidence, with the result that it's now too late. So he made that point, even though it was not then... It's
not repeated. So I had thought that water under the bridge and abandoned by the skeleton not including it. I have to confess, I don't remember the respondents, that. But anyway, there's the argument. So my lord, so can we look then at the Rhine case, which is 1113 of the Authorities Bundle, Volume 3. And I think in the quotation from the other case there in Rhine, my learned friend now wants to invoke 17a, and even in the respondents' reasons or the respondents' opposition, they didn't positively say they would have done anything. And if they are to say that evidence would have been different, then some detail needs to be given of what was at least plausible. And he gave one instance, which I'll deal with in a minute. So A, it would necessitate new evidence, or B, had it been run below, it would have resulted in the trial being conducted differently with regards to evidence at the trial. Well, strictly speaking, these points don't apply at all here because there's not a trial, and one can see how different it is because, as I say, the standard is good arguable case. not final decision on the merits, and the evidence that you adduce on documents at an interlocutory hearing like this is necessarily provisional, not final. And so there's an extra burden, if my learned friend wants to say that it would have necessitated new evidence, and what? Or it would have been, the trial would have been conducted differently with regards to the evidence. Well, that, as I say, in this particular case of Ryan, was all about the cross-examination of the witnesses. So my learned friend then says that there were factual issues of holding out and holding out of forests and reliance by shipping. And my lord, in my submission, he cannot realistically point to any new evidence that would have been required, that being the test, or would have been necessary at this interlocutory hearing on those issues. And that is because those are primarily matters within the evidential ambit of shipping. Now, shipping were not party to this application. They were in liquidation, and no evidence from shipping themselves was adduced at all, save that forests were allowed by the liquidator to look at the documents. Neither party sought, shipping's evidence would have been relevant even without an agency theory, without an ostensible theory. And so my learned friend, the highest he put it was, I don't put it any higher than we might have wanted to ask Mr. Smith. But Mr. Smith was, his fingerprints are all over the documents anyway, and had anyone wanted to ask Mr. Smith what they thought they were doing, that was surely something that would have been done in the case as it stands. So the absence of shipping from the litigation and any evidence other than their documents and their records militates against my learned friend being able to establish that it would necessitate new evidence. And so far as the representation is concerned, that is purely objective. There's no evidence that could take away the objective position of what forests were permitted to do, what they were appointed to do on the contracts. And this entire hearing has been conducted essentially on the objective interpretation of the documents. And as we'll see from Keithy Maxted, and we have seen already from Magellan, these are objective questions. The intent of shipping is purely objective. Judge them by what they do, not what they think. What they say and do, but not what they think. And so it is fanciful, Micawberish, to suppose, and he cannot establish that it would have necessitated new evidence, or that the trial would have been conducted differently, adapting that to an interlocutory case. And that is why no such suggestion, other than in the respondents' opposition, other than they didn't address it specifically, and dropped in the skeleton. And I do invite you to say that that is not made out. There's not even a credible case of it. Best he could do is we may have wanted to talk to Mr. Smith. Mr. Smith, shipping are under the liquidation, and he would have been talked to anyway had there been any thought that he could be persuaded to give evidence. I do, in respect of the actual evidence that was obtained from shipping, or in respect of shipping, perhaps I can look at the supplementary bundle, volume 2, page 493. Forests were asked to find out, my client asked forests to basically get shipping's account and obtain documents from shipping. And what they did appears in, well, it can be summarized in 37, at page 493. This is in the witness statement of Mr. Short, his fourth one. And forests have also obtained the consent of shipping's liquidators to enable forests to access emails and various exchanges. And the correspondence speaks for itself. And then he gives an account of the agency and the like. That was the time at which to get evidence from forests if forests had conceivably been willing. So in my submission, the only tentative suggestion of possibly relevant evidence that isn't objective is from shipping. And in any event, my lord, what value would evidence from somebody from shipping have had as to his subjective thoughts of reliance? Although reliance may well be ultimately a subjective test, realistically, at an interlocutory stage, without cross-examination, even if they had been able to get the liquidator's permission to allow Mr. Smith to give evidence, and he said, I did not rely, but the objectivities of the situation were that he did, because he asked, and it was Becky Guo, anyway, who issued the letters of indemnity. My learned friend didn't suggest that they would speak to her. That would have had little value at the interlocutory stage as opposed to the objective appearances. In a good arguable case test, the objective appearance is what will determine the hearing, even if in conflict with one-sided subjectivities. So no realistic evidence other than what was given was necessary, given that the way it was done below was that forests gave their own account of the relationships between them and shipping. And I do say my learned friend's submission is not supported by any detail, any evidence, anything in the documents, anything of that nature. So, if I'm allowed to argue Remicon, then many of my learned friend's submissions were to the effect that Remicon is wrong, because he said, why should the owners, my clients, be allowed to rely on a representation that they did not receive? But that is the decision in Remicon. And the decision in Remicon is that ostensible authority within the chain, within the link between the agent and the subagent, is as good as actual authority, or is actual authority in the subagent. And that is the rule stated in Remicon, and unless it's overruled, it applies. Now, my learned friend made some points about how I'll take them in a slightly different order because I noted these submissions before my learned friend's development this morning. But he said yesterday that Keithley, Maxted and Durant, the reasoning there applies to rule out the application of the Remicon principle to a case of an undisclosed principle. In my submission, it doesn't. If anything, it supports the submission that ratification is different from the undisclosed principle doctrine in itself, and that the reason for the undisclosed doctrine principle is to give effect to the true intentions of the agent and the principal. That is the rationale for it. And even if the third party did not know it. And at 126, the brief head note is where the person who made the contract did not profess at the time of making it to be acting on behalf of a principal. Well, so be it. But in this case, if I'm right on the first part of the submission, shipping did profess to be acting on behalf of the principal, albeit not to the owners, but to forests, and thereby the principal themselves. And that they're talking about profession to, they're not confining profession to the other party, is established in my submission by Lord McNaughton, who said ratification, not undisclosed principle, is the most extraordinary exception. And then perhaps we can look at 247 in the report, 133 in the bundle. Third line. And so by a wholesome and convenient fiction, a person ratifying the act of another who, without authority, has made a contract openly and avowedly on his behalf is deemed to be, though in fact he was not a party to the contract. Does the fiction cover the case of a person who makes no avowal at all, but assumes to act for himself and no one else? It would seem to exclude the case of a person who may intend to act for another, but at the same time keeps his intention locked up in his own breast. And then, the reasoning from Chief Justice Bryan, 5 lines below the red line is, "It is common learning," said that Chief Justice, who was a great authority in those days, "that the thought of a man is not triable, for the devil hath not knowledge of a man's thoughts." But, my lord, that does not apply to the Remicon case, because the Remicon case depends on objective expression of intent to be agent for the principal. We've seen that from Mr. Justice Leggett in the Magellan case. This is all about locking things up in your breast, not triable because only the devil, well, even the devil doesn't know it. So the rationale for the ratification case does not apply to the undisclosed principal case in circumstances where what is necessary in the undisclosed principal case is that the agent intend to contract for the principal, and that intention is to be collected objectively, meaning not locked up in his breast. And that supports the application in the undisclosed principal case, the contrast between ratification, where things are locked up in the breast and even the devil doesn't know it, with the undisclosed principal case, where one requirement is objectively conveyed intention. And the rule, if I can invite you to look at Lord Shand, page 136 of the bundle, 250 of the authority. The question, top right at the beginning of the redlining, the question which arises on this state of fact is whether where a person has avowedly made a contract for himself, well, not applicable in a case where he objectively displays the intention of doing it for a principal. 1, without a suggestion that he's acting a party to any extent for another, an undisclosed principal, and 2, without any authority. Well, because the point is, without any authority begs the question, because Remicon would say there is authority, can effectually bind a third party as principal. And my lord, similarly, Lord Brampton at 143, in the red-lined passage at the bottom left, but it is said for the plaintiff that when Roberts made his contract, he had within his mind an intention, though he never communicated it or disclosed it to anyone, to make it on behalf of Keithley's. Now, there's the point again, it's the devil knoweth not the mind of man, but in our doctrine, it depends on objective display of that intention. So Keithley properly so indicated supports our case as to the application. Then, my lord, we have we have my learned friend's reliance on the Playboy case and mutuality. Sorry. Mutuality is a point in my favour. The point about mutuality is that the reason that exporters could, in an appropriate case, as my friend puts it, rely on their own estoppel, is the very fact that in a different case, they could be sued on their own estoppel. So it's not anomalous that there might be some cases in which the undisclosed principle can can sue because that is the price, if you like, of mutuality. That is the price that the other party of the contract pays, if you like, as a class, for the right to sue them. So mutuality dictates it. If there's good reason why exporters could be sued on the contract, then exporters, for that very reason, should be entitled to sue on the contract. So mutuality is a beneficial principle in support of my client's case. And then finally, my learned friend relied on Bousted 5015, and in my submission again, if anything, this supports the application of the principle in an undisclosed, the principle LE, in an undisclosed principal case. If we can look that up, it's in the third volume. At page 1347 of the authorities, after the footnote 109, which refers to Remicon. And I agree with my learned friend. I had another look again at the New Zealand Privy Council case, and it deals with other points in this paragraph. The basis for this result seems to be the justice of the sub-agent's position. The sub-agent should be able to rely on the head agent's apparent authority, lest the sub-agent become liable to the third party in breach of warranty of authority. Well, that basis does not of itself apply to the undisclosed principle case. But an equivalent and parallel one does, which is that the sub-agent should be able to be protected by directing the third party at the principal as the primary defendant. So, much as my Lord Mayles indicated that, well, if there's a bill of lading claim against the solvent exporter and a charter party claim against the shipper, exporters would be first line. At the very least, they would be shoulder to shoulder in the front line. And the principal generally likely to be a more substantial entity than an agent. I know that's a huge if. The sub-agent is protected by being able to actually primarily, your contract is with the principal. That protects the sub-agent, not in the sense of relieving him from liability, but in the sense of allowing him to cite another liability of a principal. So there's a lesser protection, but still a protection for the sub-agent. But anyway, my lord, in my submission, actually, if that is one basis for the principle, there is another, more compelling basis, which is that this doctrine gives effect to the objective intention of the sub-agent and the agent. And that is, in itself, a desirable thing and explains the matter. And finally, if that is the, or a basis, as identified by the editors of Bousted, then it doesn't follow that the rule that emerges from it is confined to those cases in which the basis applies. Because general rules like this are often promulgated for reasons that apply in the commonalty of cases. But that does not mean that there has to be carved out an exception for when the rationale doesn't apply. Otherwise, there would have to be nice distinctions in the law of agency as to what is and isn't actual authority. There are sufficient nice distinctions in fact as to agency, but this would be one in principle, which is, in a disclosed case, exactly the same conduct confers actual authority, and in an undisclosed case, it doesn't. And that is a distinction that the law can do without, and it is not in the least bit hinted at in the authority itself. So don't put it in as my submission. And those are my submissions.
Right. Well, thank you very much. We move to the respondent's notice.
My lord, yes. The next matter is the respondent's notice. My learned junior is going to try and assist the court, or will assist the court, in relation to the first issue, which is whether or not there is a merits threshold that applies in circumstances where there is service without prior leave.
Very good.
I'll be dealing with the substance.
All right. Thank you very much. Yes, Mr. Gilcam.
May it please the court. As Mr. Bailey said, the point on which I'll endeavour to assist the court is whether CPR 6.33 2b and then little b, which is the sole provision on which Berge relies to obtain jurisdiction, is subject to a merits test. I suspect, I'm sure that the provision is one the court is familiar with, but just very briefly, it says this. It says that claim form can be served outside the jurisdiction without permission, where, and I quote, contract contains a term to the effect that the court shall have jurisdiction to determine that claim. Now, in an attempt to meet our respondent's notice and our reliance on the doctrine of election, what Berge argues is that there is no merits threshold to 2b. In other words, it said that 2b is concerned solely with whether there's a good arguable case that my clients, the exporters, are parties to the letters of indemnity and nothing else. The merits of the case are simply by the by and irrelevant. Now, there's a few preliminary points which I'd like to address, please, before turning to the main submission. I'll do this compactly. The first preliminary point is that the position that Berge takes is contrary to the position that it took below. In the court below, both exporters and forests submitted that 6.332b is subject to a merits test. In its skeleton argument below, Berge told the judge that the relevant law was not controversial. That's their skeleton served in response to
This seems to be correct, but are you saying, as a result, that this point is not open to them?
My lord, we did raise a Singh and Das point, but we're not taking that point on this ground, provided that we are entitled to be heard on this particular issue, which wasn't clear at an earlier point. But no, we don't take the Singh and Das point. So, but we would say this is an important piece of context, that Berge has changed tune on this point, and it is not the position that it took below, and it's now being raised in an effort to accommodate our respondent's notice.
Yes.
So I'll move on though, if I may please. The second preliminary point is this, is that the submissions that Berge makes in its supplementary skeleton, which I might ask the court to look at please, it's in the core bundle, tab 12, and it's page 131. If I could invite the court please to look at paragraph 40. This is all that Berge says in support of the proposition, for which no meaningful authority is cited whatsoever. I might just quote what Berge says. Berge says that, I quote, election is irrelevant to jurisdiction. The claimant who serves a defendant as of right needs to show a good arguable case the claim falls within the relevant gateway, but needs not show that there is a serious issue to be tried on the merits. Now there is a footnote, footnote 6, attached to that text. Two of the authorities don't matter. The first two authorities don't matter. They're our authorities, which Berge is trying to move out of the way. The only authority on which Berge relies in support of its proposition that there is no merits test is a passage from Dicey, which is quoted in footnote 6. That footnote says nothing meaningful on the point at all. All that footnote says is that there is a difference between the situation where permission to serve out is required and where permission to serve out is not required. That's entirely uncontroversial. It's obviously correct, but it doesn't assist Berge at all. It simply doesn't engage with the issue of whether or not 2B is or is not subject to a merits threshold. The last preliminary point before I move to the main part of the submissions is this. I need to say a few words just to explain how paragraph 2B, little b, ends up in the CPR. The transitional arrangements are a little bit complex. I might just give your lordships and my lady the reference where it is discussed helpfully in a case called IBM. I won't ask you to look at this stage, please, but just for the relevant paragraphs. It's IBM Volume 2, tab 45, page 925, and Mr. Justice Waxman, in this case at paragraph 127 to 137, he explains the quite complex process by which this provision came to be embedded in the CPR. I don't need to trouble the court with the details. They don't matter for our purposes. The important point is this. Prior to the 6th of April 2021, Practice Direction 6B had provided for it as part of the contract gateway for service out. In paragraph D of the contract gateway, it said that service out could be done with permission, provided that the contract contained a jurisdiction clause in favour of the English courts. That's what the position was prior to the relevant amendment of the CPR. So it's in Practice Direction 6B where, of course, permission is required under that provision. Now, what happens on the 6th of April 2021, a statutory instrument is passed, and this has the effect of essentially lifting out that paragraph D out of the contract gateway and moving it, subject to minor and the relevant amendments, moving it into CPR 6.33. So the simple effect of what's happened is we have gone from a regime where permission was required to serve out where there was a jurisdiction clause in favour of England to a position where permission is no longer required. That, in a nutshell, is the effect of the change that was made by the relevant statutory instrument that took effect from 6 April 2021. That's an important piece of context that I needed to address the court on, because it is a process, and this is vital to a submission that I'll turn to now, which is my main submission. It's vital to a process that has happened previously in Canada. As we'll see, it's picked up, the Canadian decision is picked up by a decision on appeal from New Zealand by the Privy Council where exactly the same process happened. Now, both in Canada and in New Zealand on appeal to the Privy Council, exactly the same issue arose, which was whether or not the change from a regime where permission is required to no permission being required, was that destructive of a merits inquiry? Did the merits inquiry drop out at that stage? And on both situations, both the Canadian court, the New Zealand court, approved by the Privy Council, preferred our view, which is merits remains relevant. And with that short introduction, what I might do, please, is going to make 4 submissions, one of which I've already foreshadowed, which is I'd like to show the court, please, the Canadian case and the New Zealand case. If I could ask your lordships and my lady to look at the authorities bundle, please. It's volume 1 of the authorities bundle, tab 18. And there's a case called Singh and Howden Petroleum that starts at page 312. I'm going to take the court, if I may please, to a few selected passages from the case which are significant. If I could ask the court please to look at page 313, the page references it to the authorities bundle rather than the internal pagination. We have Justice Arnott sitting in the Court of Appeal of Ontario, who just read out what's said at the first paragraph and then the first part of the the next paragraph is what the judge here is saying is that the rules in Ontario underwent a fundamental change in 1975. Now, the issue in the appeal was whether they, when this is a change, I should say, from a permission regime to a no permission regime. And what the court is having to address here, the judge is saying, is whether that is merely a procedural change, essentially designed to save costs and to remove a preliminary step in the process of service out, or is it something far more radical and wide-ranging that changes the fundamental basis on which jurisdiction is to be exercised? The start of the second paragraph of the judgment, the judge says that he refers to the old rule, and he says Rule 25 sets out various ways in which service out is required. And if we come over the page, I won't ask your Lordships, my lady, to look at this in particular, but there's a reference to a judgment from Lord Justice Linley, where the Lord Justice is referring to the familiar merits test. That clearly applied in Canada under the old rule where permission was required. Now, if I could take the court's attention, please, to page 315 now of the authorities, and you'll see the red lining at the bottom of the page. And what Justice Arnott is doing here is he's summarising the effect of the change. He says the old rules are being changed where permission, which was once required, is now no longer required. He says that's the effect of the rule change. Now, the critical issue in this case is what's the nature of the change? Has it abolished the merits test, or is it simply removing an essential preliminary step in the procedural process of obtaining jurisdiction? The answer that the court gives on this is found at page 322 of the authorities bundle, and it's the text right at the bottom of the page with the red line. And Justice Arnott says this, and I quote, "It's my view that the intended effect of the amendments was to remove as unnecessary one of the two steps in the ultimate decision as to whether service out of the jurisdiction should be allowed." And critically, I'm going to ask the court also to look at the statement of conclusion on page 324, right at the top of the page in red lining. And the judge says this: "In the result, I am of the opinion that the divisional court erred in the approach that it took, and that on the service out of Ontario in this case must be looked at by the court having in mind the same principles," I emphasise those words, the same principles which govern the scrutiny by the court of the process issued under the old rules. That's the important point. Now, part of the reason why I've taken the court to this decision from Ontario is that these exact remarks are approved and said to be convincing by the Privy Council on the appeal from New Zealand. I might try and, conscious of the time we have just a moment, I can come to the New Zealand case after the break if that would assist the court. I think I'll need more than a...
If you're going to need more than 30 seconds on it, then you'd better do that. All right. 2 o'clock.